Yeah, that's the number one question I get from all of my clients, especially during the initial consultation is, what am I looking at for a DWI? Well, obviously, our number one goal always for any case is to get the case completely dismissed, find enough evidence to prove that our client is innocent, or poke enough holes in the state's evidence to convince them to dismiss it voluntarily without having to go to trial. That's always the first thing that we try to do. But assuming that we are unable to get a dismissal and we have to pivot and start negotiating plea bargains for our clients, the most common plea bargains for a first-time offense are either straight probation, which means that you are admitting that you're guilty, the court is convicting you of the DWI, but instead of sending you to jail, they're allowing you to serve your jail sentence on probation instead, and that's going to be for a pre-agreed number of months, usually between 12 and 18 months on an average DWI case. The alternative to straight probation is what's called deferred adjudication probation, which is generally considered better than straight probation, but it does have, it's a bit of a carrot and stick situation. So deferred probation is just like regular probation. There's a period of months that you're going to serve on probation, doing community service and, checking with your probation officer, maybe having to do some random drug tests, and it'll be for a predetermined number of months instead of going to jail. But the benefit is that if you successfully complete all of the conditions of your probation, then at the end of it, the court, the judge, will not convict you of the DWI. And so you won't have a conviction on your record like you would on straight probation. So that's a really good option for most of our clients. There are a couple of other alternatives to probation for a DWI. One of them is what we call a reduction to a lesser included offense. And what that means is that we can sometimes convince the prosecutor to dismiss the DWI itself and actually charge you with a lesser offense that doesn't look as bad. One of the most common options there is what's called obstruction of a highway. It is a Class B misdemeanor, which is the same level of offense as a first-time DWI offense, but it doesn't have the stigma of a DWI. It doesn't involve any intoxication. So it doesn't involve alcohol or any other forms of intoxication. And it's an offense that doesn't affect your license in the same way that a DWI would. So that's a really good option for a lot of clients if we can convince the state to dismiss the DWI and then plea you to an obstruction of a highway, which then you would do either probation or deferred probation on. The other likely outcome, and this depends on what county your case is in, but some prosecutors' offices offer what are called pretrial diversion programs. So these are programs that you agree to, well, you have to apply for, and if you get into them, then it's sort of like probation. There are classes you have to go to. There's regular drug and alcohol testing. There's usually some community service requirements. But if you successfully complete the program, then the prosecutors agree to either dismiss your case or reduce it to a lesser included offense. And so they're usually about 12 months long, which lines up with the average probation. And so those are really good for first-time offenders or for anyone who can apply and get in. Sometimes, depending on if your lawyer, has a good enough relationship with that prosecutor's office, there are strings that can be pulled to convince them to allow you in to the program if you otherwise wouldn't qualify. But you're going to have to talk to your lawyer about that and see if you can get in.